The question is that the bill be now read a second time. Leader.
Mr. Deputy Speaker, I beg to move that the proceedings on the business set down on the order paper for today be exempted at this day's sitting from the provisions of Standing Order Number 2.
The question is the motion moved by the leader. As many as are of that opinion say aye. To the contrary say no. I think the ayes have it. The ayes have it. We move on with the second reading for the Police Force Amendment Bill. Mr. Desmond Choo.
Mr. Deputy Speaker, sir, I declare my interest as a board director of Sabana Jurong Private Limited, which owns Atos Holdings Private Limited, an auxiliary police force. The bill marks another important step ahead in protecting the safety and security of Singaporeans and enforcement officers. It is perhaps also most opportune during the 200th year of the establishment of the Singapore Police Force. The enhancement of the SPF's operational capabilities is greatly welcome. Section 114A now explicitly affirms the protection of police officers from personal liability. Officers must be assured that they are protected so that they can discharge their duties without the nagging worries of personal liabilities while legitimately carrying out their duties. We note that this has been carefully calibrated. Greater protection is afforded to our officers, but balanced by criminal liability and disciplinary actions to prevent and punish those who flagrantly abuse their powers in bad faith. Our officers do not operate in a risk-free, benign, and simplistic environment. They often have to rely on their training, exercise judgment, and take on certain risks, especially in critical, complex, and time-sensitive situations. In my years of running operations in the police force, I have seen that even the best officers could and would make mistakes. And these mistakes were crucial to the police's collective learning. Mistakes can also come from taking well-managed risks. Nothing affects the ability of an officer to discharge his duties more than knowing that the law does not protect them, or even against them. I hope that these considerations can be included in the upcoming regulations to be prescribed by the Ministry in determining what constitutes good faith and reasonable care. These regulations should not also be unnecessarily rigid or prescriptive, such that it stifles execution in fluid operational situations. Yet, neither could it be so broad as to leave practitioners directionless. Can the Minister share what might some of these regulations be? What were examples of cases that the officers did not act in good faith or reasonable care? Enforcement officers work in a hierarchy with clear chains of command. They are usually either guided by supervisors or standard operating procedures. If there is indeed a situation when an officer did not act in good faith and or reasonable care, then what is also the liability of officers in a chain of command? I hope that officers do not lose operational effectiveness in becoming overly circumspect in guiding their officers or executing their duties. Sir, I also seek a few clarifications and suggestions on the amendments for the Ministry's consideration. My first suggestion relates to motorists who evade road barriers. Under Section 26(8)(a), a person guilty of evading a road barrier faces a fine of up to $10,000, imprisonment of up to 7 years, or both. The Mackenzie Road incident in 2017, which left 2 of our officers injured, has shown us how brazen a minority of motorists can be in evading road barriers. Evasion not only reflects intent to conceal criminality, but can also cause considerable danger and inconvenience. Could the Ministry consider imposing a minimum punishment, including a mandatory jail term, for evading road barriers? I believe this will serve as a forceful deterrent, demonstrating the Ministry's zero-tolerance stance against such acts. My next suggestion relates to the liability of employers of auxiliary police forces, or APF, under Section 87(9). At present, liability under Section 87(9) is not explicit within the following provisions: Section 87(5), bracket 7, and bracket 8. These subsections are important in ensuring that MHA retains regulatory oversight over how EPFs are run. For example, Section 87(7) underlines the need for Singaporeans to retain a controlling interest in APF companies. Should we attach legal liabilities for infringing the above-mentioned provisions? Can I also clarify that Section 88 also applies to entities and persons with indirect control over the board of the employer of the auxiliary police force? Now, for example, Company A has indirect control of the employer of the APF via a controlling stake in the parent company owning the employer of the APF. Ultimately, the ministry should be afforded greater regulatory oversight over the APFs, ensuring the APFs maintain the highest standards expected. Mr. Deputy Speaker, sir, at its core, passing this bill will strengthen our ability to keep the people of Singapore safe by judiciously strengthening the operational readiness of the Singapore Police Force and the Ministry's oversight over the APFs. Our officers must be provided with the full armour of the law to take their stand against criminals and discharge their duties. Deputy Speaker, sir, I support the bill.